Hello and welcome to another edition of the ASBSD's videocast on open meetings. I'm Wade Pogany, Executive Director for the Associated School Boards of South Dakota, and today's topic is about the Open Meetings Commission and what school boards should know when they're dealing with open meetings laws. Joining me today is Dr. Randy Royer. Randy is the Director for Board Development, and Mr. Gerry Kaufman. Gerry is the Director for Policy and Legal Services. Thank you, gentlemen, for being a part of this discussion.
You bet.
You know, in previous discussions, we have talked about the importance of why school boards should follow all the open meetings rules and laws. But if an open meetings rule is violated, if something happens that violates the law, school boards will then have to deal with the Open Meetings Commission. So my first question is, what is the Open Meetings Commission and how does it affect school boards?
Okay. Open Meetings Commission is an entity that's created by statute. The legislature created it in 2004. It consists of 5 members. They're all state's attorneys within the state of South Dakota, and they are appointed by the Attorney General. And then they will review complaints that go through this local state's attorney up to the Attorney General's office, goes over to Open Meetings Commission, commonly called OMC, and then they will review those alleged violations and make a decision.
Okay. If a board were to violate an open meeting statute, what is the procedure that they probably would go through if they came before the OMC or the Open Meetings Commission? What's that process like?
Well, again, like I just indicated, most of the complaints, almost all of them, originate either out of a member from the public or the media. They will file a complaint with the local state's attorney. The local state's attorney then has one of 3 options. After investigating the complaint, they can either dismiss the complaint, they can prosecute it, because most of these laws, all of them are Class 2 misdemeanor, they're criminal violations, or else they can refer the complaint up to OMC. And if it goes up to OMC, then it goes again through the Attorney General's office. The Attorney General's office will let the school board know or other political subdivision know of this complaint that's been filed and ask for a response. And then a response is given, and it can result, usually does result, in what I would call a hearing before the Open Meetings Commission.
So that some action would have to happen, then a complaint by someone would have to be brought then.
Correct.
For that to happen.
Correct.
What are some of the most common open meetings violations? What do we hear about in front of the OMC, generally, general categories?
Probably the biggest areas of complainants are executive sessions, violations of executive sessions, and agenda violations, where the meeting hasn't been posted 24 hours in advance, or all the items on the agenda have not been included in that posting. But executive sessions are another big one that happens with boards.
And we've talked about both of those issues in some previous videocasts that we've had, and the importance of why those are really critical to be followed. Are there any examples of precedent cases that would illustrate these 2 areas as far as cases that came before OMC?
Definitely, and just a little history, there are 41 cases that have been filed and decided by OMC. Approximately 27 of those ended up in reprimands of the political subdivision. And I think kudos should be given to school districts, because of those 43 or 41 that were filed, 5 were against schools. School has been reprimanded, or different school districts, only on 3 occasions in 10 years. So schools overall do a really, really good job. But in response to your specific question about examples, Randy mentioned the agenda kind of issues. The law recently changed, but over the course of the years, like Brown County case, City of Aberdeen case, were reprimanded because they would post their agenda, but they posted their agenda 24 hours in advance, but where the public couldn't always see it. It would be inside the building, by way of example, or facing inside on the outside door. Well, the law recently changed a couple of years ago that says it has to be readable, accessible, visible at least 24 hours before the meeting. So in those cases, the political subdivisions were not reprimanded because the law at that time said no violation. Those same things being done right now would result in a violation.
How about, are there any precedent cases around executive sessions? Anything stand out there?
Well, there are several, and generally what happens is the stated purpose for the executive session is not followed, where a board will go into executive session to discuss a certain item, and then a board member brings up another topic and they discuss that, and then they come out of executive session and make a motion based upon that discussion. So it's clearly that they violated that executive session reason.
So those are two big categories then.
And I would expand on the exec session if I could. There have been several cases where Open Meetings Commission has come out very, very, very strongly and addressed one of the exceptions within the exec session statutes. There's 5 exceptions. One of them specifically deals with communication and review communications from counsel, legal counsel, regarding contract matters or litigation. OMC has said very strongly in a couple of cases, in about 3 cases specifically that I can think of, that contract matters are not a stand-alone exec session reason. OMC has said in one of the cases that if contract matters were an exception in and of itself, then almost everything a political subdivision could do, it could go into executive session, and the exception could eat up the rule. It has to involve the school district's attorney's direct involvement, either in written form, on the phone, or in person, to get into that exception. Very critical for boards to understand that just because it's a contract matter does not give the board the authority to go into executive session.
Okay. So what advice would you give school boards to, maintain their compliance with open meeting rules? What would you say to them?
Well, based upon those 2 basic reasons, first of all, make sure you post your agenda 24 hours in advance, and it includes everything that you possibly can include at that time. Certainly at times when you approve the official agenda, you may add some things, but be very careful in doing that. And the other thing is the executive session. When you go into executive session, make sure you stay on topic. I would charge the chair with that duty to make sure that you stay on topic and you don't stray from the stated purpose of the executive session. And also when you make the motion to go into executive session, that you state exactly the reason for it and you stay on topic.
And I would add one thing, if I may, Randy, too, is like with the open meetings series that we're doing right now, continual education as school board members get elected and somebody leaves. A perfect time to review the open meetings rules would be at the school reorganization meeting in July. Do it at least annually, if not, twice a year, whatever. And like Randy said, your chair is instrumental, but all your members of the governing board have a responsibility to make sure the rules are followed. And the governing board should invite and welcome and encourage, like the superintendent, the business manager, to also help monitor. It's a community effort because the following the laws in this area are so significant.
Yeah. So it's really incumbent upon any board member to make sure they know the rules. You don't want to go before the Open Meetings Commission in violation of that, and so it's just a matter of educating ourselves on how that works.
Correct.
And like Gerry said, school boards have a good track record on that, and we want to make sure we maintain that.
Absolutely, absolutely. Thank you, gentlemen, for joining me, and thank you for listening.